Everyone, thank you for joining us today. We're really looking forward to today's discussion. I'll be the panel moderator today, so I will introduce myself and then turn it over to my panel members to introduce themselves. My name is Alexa Lamaris. I'm currently Privacy and Cybersecurity Counsel for WestRock, but I have previously worked as the North American Privacy Officer at Invesco. So I do bring that background to today's conversation that is more tailored to the financial services industry. I will turn it over to Shampa, Ted, and Ron to introduce themselves. Shampa, please go ahead.
Hi, everyone. I'll get started. My name is Shampa Chatterjee. I'm currently Director of Privacy and Information Security Compliance at Silicon Valley Bank, which is a division of First Citizens Bank. Prior to this, I have worked at American Express for about 20 odd years in different roles. I have a background in computer science, so I actually started as a programmer at American Express. And then through various risk and compliance roles, I managed privacy and cybersecurity for American Express. I'm delighted to be here today. Thank you for having me.
Thanks, Ted.
Hi, I'm Ted Claypool. I am a partner with Womble Bond Dickinson here in Atlanta. I also was in-house as the tech lawyer and data security lawyer for Bank of America in the past, and also in-house with a company called CompuServe. So my practice is mostly privacy, data security, and anything in the digital range.
Great, Ron.
Hi, I'm Ron Whitworth. I'm the Chief Privacy Officer of Truist, now located in Charlotte, North Carolina, although I came from Atlanta, so great to be back with this audience again. And I'm also a lawyer by training, but am situated in the compliance risk management group within Truist. I'm responsible for the privacy program and also technology compliance, which includes cybersecurity. So thanks for having me.
Great, thank you. And a big thank you to each of our speakers today for their being here and for sharing their expertise. So here is our agenda. And I do want to make the point that we want this to be an open conversation that really serves our attendees. So please feel free to type any questions in the chat. I will be checking for those questions and we'll try to fit them into our conversation. And so we are asking for questions kind of in a written format, and we would appreciate your working with us. Thank you. So, and before we start, we do need to state our disclaimer. So the information provided during this CLE does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. The views expressed during the CLE are those of the individual presenters in their individual capacities only, not those of their respective employers, the Georgia Bar, or the group as a whole. So with that, I will kick off the real content of the presentation. So Ted, would love for you to kind of get started on the background, maybe giving us a sense of the why of the SEC promulgation of these rules. Oh, Ted, I think you're on mute.
Yeah, sorry about that. I find people like me better that way. But I think there's a number of reasons that that the SEC got into this racket, as everyone else seemed to be at the time. One is that governance is something they've always done. I mean, since the 1970s, governance has been a big issue for the SEC. That's one of their methods of management of the companies that report to them, is insisting on certain levels of governance. And one of the interesting things about data security is it is a governance issue. It's mostly about how you set things up and what your policies and procedures are. There's some technology involved, but it's primarily governance. But I think the second thing to throw in there is that one of the things that they're also charged with is making sure that the system runs appropriately. And one of the things we're seeing, particularly with ransomware attacks, which have picked up over the last 5 years, is that these attacks have a way of shutting down entire companies and shutting down important parts of the system. And so this is one of their methods of going in to try and make sure that the system is operating and flowing appropriately when we now see the risks are coming from attacks and cybersecurity issues.
Yeah, absolutely. And I think knowing that this is kind of a change in the scope of their kind of previous promulgation of the rules, I think, Ted, you had kind of discussed the importance of some of these financial services organizations in kind of their mindset of what is the organizational risk. And so, Ron, I think maybe if we could talk about kind of that scope and who these new rules apply to, kind of speaking through the concepts of these kind of covered market entities, and maybe even if there's any applicable organizational structures within Truist.
Yeah, sure. So, the SEC rules do apply to to the covered entities that are sort of, broadly covered by SEC regulations. Securities advisors, investment advisors, investment companies, that type of thing. Now, to your point, Alexa, within a financial institution, you may have a particular component of your organization that is covered specifically by SEC that wouldn't necessarily cover the entire organization. So for Truist, for example, we have Truist Wealth, which includes our broker dealer, our wealth management services, et cetera. And so the dynamic with a company like ours, not unusual at all, is that the SEC is particularly focused on those lines of business and have their own dedicated oversight routines, dedicated exams, et cetera. That being said, for incident response and other cybersecurity obligations, you're often looking big picture. So you have to have the big picture view and then also be very attuned to the specific lines of business that are directly subject to SEC regulation, because there may be some nuances, and there are, in fact, as we'll get into.
Yeah, fantastic. Thank you, Ted. So I think, to kind of pivot to some of the main requirements, when we talk about disclosure requirements, Ted, can we cover what some of those kind of new promulgations are, and some of the key factors about the SEC requirements?
Yeah, I think the biggest change for people is that the disclosure is required when there's been a cyber incident, and almost immediate disclosure. They're requiring 72-hour disclosure to the SEC and a 24-hour disclosure if you've paid a ransom. And that's an interesting area because people always ask about the ransom payment, because there's a very weird way that the government is looking at this. Right? I mean, the government tells us that we're not supposed to pay the ransoms. If you talk to law enforcement, they say that you can't and shouldn't, but there's nothing that says that you'll either get fined or go to jail if you do. They know that it's likely that you might. So it's very similar to the way that the government treated, for example, kidnapping out of US executives out of Central America and Colombia 30 years ago, in that they were told don't pay the ransoms, but the government actually helped facilitate it in some cases. They don't want to look like they are suggesting that this is a good thing to do, but they're also not going to make a hard and fast rule about it. Every time one of these rules comes out, I immediately look to see if they're actually going to penalize anyone for it, and they don't. So one of the issues here is, rather than go in and say you can't do this, they're saying that when you do it, you have to report to us, and you have to report it to us immediately. And that reporting is likely to involve how much you paid. And probably you're going to have to give an accounting as to why you thought it was important to pay in this case.
Yeah, that's fantastic. And so thank you. I think we've certainly covered some of the immediacy, the materiality of what needs to be reported. Do you have any additions in terms of kind of the confidentiality of some of that communication?
Yeah, no, that's important
Yeah.
because for years, that's been a big thing, especially in the financial services industry, that if you have a breach and you do report it, often you kind of get punished for reporting it. I mean, I remember when I was at Bank of America in the 90s, and one of our competitors, Chase, had a big breach, and they ended up tracking down and catching the guy. And then they made a big press announcement about it, that they had caught this guy and gotten back the $26 million he took. And all anybody could talk about was, oh my God, they got hit for $26 million. And their stock went down very quickly. So, it's been an issue in this industry for a long time. So one of the things the SEC built in was a promise of confidentiality. You need to make the disclosure to them, but they will keep it quiet.
And in the SEC keeping some of that quiet, will they ever share any of that information with other organizations? I think we're going to talk a little bit later about CERCIA, so I kind of want to make that tie, even though I know we're going to talk about the CERCIA requirements more in depth later.
Yeah, I mean, that's my understanding is that at least in anonymized, it will be shared, it will be put into the database so people can see what's happening. I actually personally don't know, maybe somebody else on the panel knows, whether it will be open for FOIA requests. Because that's another big question if you're the institution involved.
It's a great question. I'm not sure. So, we're talking about, some of this information being reported from an organization to the SEC reporting that to CISA, and either of those records being FOIable, regardless of that promise of confidentiality that the SEC gives you. Any thoughts from Ron or Shampa?
Yeah, I don't know if that's a settled question or not. I know that there's been discussion about that intersection between SEC reporting and CERCIA, and there's even a proposal from some of the banks that have gotten together and said, hey, would the SEC be willing to kind of leverage the CERCIA process itself, actually funnel it through that so that the SEC receives it that way. But to Ted's point, confidentiality is really a critical piece of this, and it's not just to protect the bank's reputation per se. It's also, we're talking about ongoing incidents that could potentially impact consumers further than they already have, and there needs to be that cloak of confidentiality where the banks are able to continually work an incident. And as you said, Alexa, the culture of information sharing is really outstanding. It's really grown up in the last 10, 15 years in the banking industry, particularly. Where banks do share information and they're able to help their peers prevent similar instances, and then the actual instance that you're reporting, you might be able to stop the proliferation of that particular bad actor's actions and so forth, provided that you have strict confidentiality around the reporting of those incidents. And so those are some of the things that the industry is discussing and commenting on, and making sure that there's a proper awareness of on the regulatory side, so that that is a top of mind consideration.
Yeah, thank you.
Let me jump in quickly, Alexa, and just say, that's one of the things that we realized back in the 90s with B of A was that essentially this is not a competitive issue, right? Because if you're a bank and the bank across the street, which is what we always used to call First Union, but if the bank across the street gets hit, then all banks suffer because everybody says, oh no, the banks are vulnerable. And so sharing has been something that the banks figured out a long time ago that they probably ought to do in this area. And I think of all of the laws that we're talking about and the rules that we're talking about, you're seeing it sort of fill in the edges from a security standpoint with the big banks have already been pretty well covered on a lot of this stuff. But some of the other companies around the edges are hit by the New York rules or the SEC rules or others. But the banks have always been good at this because they know data security is not a competitive advantage issue.
Yeah, and Ted, I think that's a great point. You'll even see in some of kind of the SEC background or justification for this proposal that connectedness of these entities, right? As kind of something that might hit one part of the industry being very easily able to make its way into these connected organizations. I think we have talked a lot about just one aspect in terms of kind of reporting and disclosure requirements, but there are so many other requirements around what could be viewed as a comprehensive cybersecurity regulation. And so I would love to turn to Shampa to cover some of these proposed, just these different aspects that might not only be focusing on reporting to the SEC. Oh, Shampa, I think you're on mute. Sorry.
It's a rite to passage. Thanks, Alexa. So I want to take a quick step back and talk about something that Ron had touched upon earlier, is that for some of the larger banks that I've been part of and that I've seen around me, it's some of these entities which are kind of the non-bank subsidiaries or affiliates of the holding company roll up to the parent, just as maybe your banking affiliates like your private bank or commercial bank might be rolling up. It's very entirely possible that there is an enterprise CISO with a centralized cyber risk management program. However, for some of these smaller entities, you may lean upon some of those centralized processes, but also there is a requirement that when you outtask some of these requirements, you don't necessarily outsource the risk. The risk still lies with you as the owning line of business. And that's where, you will need to still have your, your broker dealer or your RIA or your funds. They should still have their localized procedures and compliance manuals, et cetera, that detail the obligations of the business itself. So when you look at some of these proposed regs from the SEC, they will all look very familiar if you are especially from a larger bank perspective, because some of these have been there forever. The FFIEC exam manual, the IT handbook around information security, it basically has all of these requirements in there, and that has been in place for a very long time. So some of these may appear as table stakes to someone, but it's important to note that if you are a smaller non-banking affiliate, you still have to have something in place to show how you're adhering to some of these broader enterprise level requirements. So for example, cybersecurity policy is a great example. You may have an overarching policy at the enterprise level. However, some of the controls therein, you inherit some of that, but then you also have to have your own kind of processes and procedures, your control testing, your annual assessments, et cetera, in place to be able to demonstrate that you are meeting some of those requirements. I think record keeping is a great example. You may have an enterprise record retention schedule and policy, and you need to, because you have to retain official business records for regulatory purposes. However, once you have met those requirements, do you, within your business own processes or systems, have an automated purge process or not? And later on, I'll share a specific example that I experienced with recently that actually talks about those automated processes and having those automated processes in place. Incident response program, right? Customer notification. So I think every US state has data breach notification laws in place. And we have to have a written incident response program that speaks to some of those obligations. that come at us from all these different states as well, in addition to the federal requirements, of course. So I just feel like, the whole slew of requirements that you see on the slide, I feel like they seem very familiar to most people. However, it's important to note that SEC is now coming and being quite prescriptive about some of these requirements and making sure that, some of these that may be smaller entities also have their controls in place that speak to some of these requirements.
Yep, fantastic. Thank you. I think you, Shampa, might have even been alluding to kind of the impact that a lot of this quick reporting can have on an organization if there are or are not those automated procedures in place. So I think you were almost leading yourself into this slide. Could you talk a little bit about, I think we get so much value from getting your organizational experience in terms of how you might look at the life cycle of a cyber incident and fitting reporting into that. So how might you think through what your organization has to do in order to report basically immediately if it has to do 24 or 36 hours reporting?
Yes, that's a great actually segue into where I was going to go anyway, Alexa. Thank you for that. So recently, I did a lot of work with the 36-hour notification ruling that came out of the FDIC, OCC, and FRB. This was, I think, effective May of 2022. And that was more a requirement of early advisory or early alert to these regulatory bodies before maybe your forensics has even started, right? So what they're saying is, let us know as quickly as you can, especially if you see a computer security incident that reaches a certain threshold of materiality. So obviously, as with any other regulation, there's a lot of gray in how do you determine what is material, right? How do you define that for your organization? So a bulk of that work went into just determining and defining it within our organization's risk management framework. What is considered material, right? So I just feel like some of these are cross-functional kind of topics that include a lot of analysis and a lot of engagement with various players, such as legal, risk and compliance teams, regulatory affairs, of course, your CISO, your global privacy office. There are just so many players that each have like individual pieces of this that need to come together and determine some of those criteria and put procedures in place so that every time this happens, we are not all rushing to we're not all trying to voice our opinions at the same time, where time is really of the essence and we need to have something out very quickly. I think all of these 5 pillars that you have, these really should be codified within your incident management and response procedures, and that is what we have done at our company to make sure that roles and responsibilities are defined, and everyone knows who is the decision maker at any given point in the conversation.
Yeah, fantastic. Thanks, Shampa. And I think specifically looking at the impact of reporting to the SEC, what I think has been interesting and what I've seen kind of organizationally from my perspective is a new set of legal counsel being brought into the conversation in terms of the securities attorney's perspective. And so, Ted and Ron, I wonder if you have any considerations about there's so much in these pillars that involve, a lot of brokering between people in different types of roles. You'll have individuals in the forensic role, usually in the privacy and cybersecurity role. Now you're adding, SEC-based attorneys. And so I wonder, what advice can you give to sort of help bridge the communications gap during these events with this new form of reporting?
Group hugs, primarily. And that I'm being somewhat serious about that, in that the team should, as Shampa was saying, they should get together ahead of time and know each other. That's one of the biggest issues. You don't want to have an emergency and have everybody show up in the room and nobody's ever met. And that's when you begin to get people sniping at each other and people staking the flag for their part of the organization, or people covering their backsides by pushing responsibility over on somebody else. If you've spent the time with some of the other people, whether it's a tabletop exercise or just getting in the room to discuss how some of this would work and what everybody's role would be, it makes it much, much easier when the emergency actually happens. Ron, do you think that's right?
Absolutely. Tabletops are critical, and for some of us, it's mandatory, but I think that's where the rubber meets the road, because I think a lot of organizations can draft policies that look great and they say all the right things and they include all the right people, but then when something happens, that policy gets thrown out the window and it's chaos, so you've got to really have tabletop exercises that people take very seriously and include the type of parties, Alexa, that you're talking about. Even up to your C-suite board, you should include them in certain types of exercises, because you really need to go through and that type of exercise and take it very seriously to see some of the nuances and actually to detect where maybe your policies were aspirational and don't actually work for your organization. This is not a cookie cutter area. You really just can't take something off the shelf that might work perfectly for your peer and just roll it out of your organization, because every organization is just a little bit different and it has to work for you. So I agree with what you're saying. You've got to put down on paper what you think should happen, but then you really do have to practice it and poke holes in it and then revise accordingly.
Absolutely. And I think, including new individuals, if this is something, for those of us on the call who might be in an in-house position, I will say having included our securities council kind of early on has been such a useful exercise. I think in many ways, being able to have a really pointed view, usually my privacy cybersecurity lens is kind of thinking so much more about the facts in a different way. And, being able to test things with securities council and see that, the analysis is really different for them, and kind of what they're thinking about in terms of materiality or what they've done in the past, or even how they report up to general counsel and the C-suite is different. So I think that has been a really useful exercise that we've been able to take on as well. I think a theme that we as a group have kind of hit on throughout is the kind of connectedness between privacy and cybersecurity practitioners. And I know in the organizations I've worked with, the ability to sort of understand your data and where or how it's processed is really foundational to be able to protect that information. And I think many of us would agree that the strengthening and maturity in kind of one of these areas usually helps another area. Shampa, can you talk about the role of privacy leads and practitioners in assisting companies to comply with these requirements and these new regulations, and also kind of interpreting any of these requirements through a privacy lens?
Yeah, sure. So I am not a lawyer, but I am a practicing privacy and security risk professional for many, many years. And, over the years, I have seen the journey of privacy maturing into a risk discipline of its own. It didn't used to be. When I started doing privacy, I kind of fell into it, if you will. I wasn't even in a privacy team. I was in marketing capabilities. And I was building a choice capability, a consent capability that we rolled out across the globe for American Express at the time. It was only later that they put me in a risk and compliance organization. And I was part of probably the first group of people that formed the privacy office at American Express. Security, on the other hand, I feel like it's a more mature discipline. So I feel like organizations, big banks that I've had the fortune of working at, they had the maturity to understand that unless these two disciplines work together and understand each other's requirements, it's probably not going to, give you a holistic, comprehensive coverage that you require. While security concerns itself with all information, privacy, I feel like, is a subset of data, which is inherently having a higher risk profile, if you will, because this is where you're talking about your PII, your sensitive PII, things that can cause individual harm, if you will, should it be compromised in any way. So wherever, I have worked, I have assisted the CISO and the security organization or the incident management and response teams wearing my privacy hat to explain to them what should be considered, the higher risk profile data and why we should have elevated security controls to protect them. I feel like in all organizations, the other thing that I did want to touch upon is as a risk and compliance professional, I do work very closely with our general counsel's office, our lawyers, who really help me understand, permissibility, who help me understand the intent of the law. But I think as a compliance and risk professional, maybe Ron will agree with this, is we kind of have that ability to set a higher standard for the organization. So we can say that instead of responding to this particular law or this particular regulation, let's have a program that has this higher standard that we are all adhering to as a company, which then prepares us for additional regulations, because these laws and regulations are coming at us like every day, US state privacy regulations, right? So instead of having that reactionary kind of approach, building that program, which adheres to a higher standard, I think has been very helpful, especially in my role currently here at SVB.
Yeah, Ron, would you agree? Any additions?
Oh yeah, I agree 100%. Very well said. Privacy really did used to be a compliance or legal exercise, and it just really is not that anymore. Ted mentioned earlier, we don't compete on security. That's absolutely accurate. We work together. Privacy, on the other hand, while we work together and we have great relationships across all the banks, it is becoming a competitive business issue. And we now have seats at the table with our business partners that we never had before in terms of innovation, technology, uses of data and ethics, et cetera. And to Shampa's point, when it comes down to executing a program, or if we're talking about incident response specifically or cyber, you just have to kind of bring all these pieces together and see it holistically. I think where companies run into trouble is when you have silos that just are operating in their silo and they're not necessarily talking to each other. You need to think about it holistically and think about, hey, if we have a situation, whether we call it a technology incident or a cyber incident or privacy or HR or fraud, at the end of the day, what is the impact to the consumer? And let's think about it holistically about that individual and work together for that remediation. And that's just a much better way to approach it.
Yeah, I think that's fantastic, Ron. I think thinking about the impact of any of these events or any of, an incident that could trigger reporting not only to the SEC, but, to these other regulators that we're going to discuss later on. I think, we've covered privacy and cybersecurity can be kind of hand in hand. But one thing that I think sometimes, especially in the world of very specific privacy lawyers who, Shampa, as you said, are only thinking about one certain set of data, what can get lost is the concept of sort of operational risk or risks to system that might not necessarily have kind of informational access as part of it. Ted, can you talk about that distinction and how that might impact reporting to a regulator?
Absolutely. And in the SEC rules, even as they're talking about data, they talk about three aspects that you need to be aware of: confidentiality, integrity, and availability. Right. And so the privacy issues kind of fall into the confidentiality side. Are you going to intentionally keep this stuff private? And one of the reasons, as Ron was saying, that there are actually some differences between the banks or other companies in how they do this is some people tend to lean more toward privacy. Some people tend to lean more toward being able to market and use that information. And so it's becoming a client issue. But the confidentiality all sort of falls into that, and we understand that. The other two, people don't really get that much or hear about that much, partly because it's not as much of an issue usually thus far. Data integrity in particular, essentially, I used to give talks on data integrity, and I would start out with a photograph of my face on the body of 1978 Arnold Schwarzenegger at the beach. I mean, so this obviously there's no data integrity in this. You can easily go in and take a file and turn it into something that is simply not true and obviously not true, or you can turn it into something that is problematically difficult to tell that it's not true. And so you don't see much of that because there's not a lot of money in changing data, right? I mean, you basically have crime where the money is, in the old Willie Sutton method of looking at it. And part of where the money is either taking information and being able to sell it, or taking information and selling it back to the people you stole it from in the first place, or stopping the information from being able to be distributed, which is the third part of this, availability, and then selling the access back to the people that originally had it. And so integrity kind of gets lost, but it is a huge issue, and it's something that I think is going to get bigger as AI gets bigger. But availability, we're essentially talking about not IT, but OT, operational technology. And it's one of the areas that, I mean, what's interesting is, as we're talking about financial services here, kind of your IT is your OT in a lot of ways. But like, we do a lot of work at the moment for energy companies. And so they have information on one hand, but they also have pipelines and chemical companies and drilling rigs on the other hand. And that's purely operational technology. And, you need to be able to separate your information technology from your operational technology, because you really don't want somebody to slide in through your email system and go shut down all the oil wells. This is something that I think we all remember the problems that Target had when it had its little oopsie several years ago, and lost somewhere in the neighborhood of 46 million data sets, which include credit cards for its customers. But one of the problems was the bad guys got in through a vendor portal all the way in the back of the system. And the issue was they were able to work their way all the way up into the cash registers. So that's a bad thing. I mean, you should be able to have this divided out. And that's one of the issues that the SEC is talking about here in discussing availability, is that, your operations are equally important as the confidentiality of the data. And we don't talk about that much, or we didn't before the Continental Pipeline accident or problem. And since then, that's become a much bigger issue that we're going to talk about in the next section of this discussion.
Yeah, absolutely. And I will go ahead and get us there. And I will say, Ted, I think you're absolutely right. I mean, coming from the perspective of being in manufacturing now, there is a much clearer distinction in different organizations that aren't just financial services, where your OT could really bring a lot of financial struggle if that is impacted in any way through an incident. I think that, being able to distinguish between whether the threat actor is really kind of holding any OT ransom and that whether that has any, downstream impacts on your business is something to consider, even in the financial services industry. This, slightly less so, and it applies definitely in a different way. Ted, I think you were, teeing yourself up for Cercia. So I'll turn it over to you. How can we talk about maybe distinguishing this from the SEC regulations and highlighting what organizations need to pay close attention to?
I think partly Cercia is primarily about reporting. Whereas I still think, even though there's a reporting aspect to the SEC, I still feel that's primarily about governance. And so, essentially we're talking about the Critical Infrastructure Act of 2022. And once again, it was sort of highlighted in its need by the Continental Pipeline attack and everybody running out of gas here in Georgia and other places because, and it's interesting because the bad guys in that case didn't actually get to the pipeline and didn't actually shut it down. But the reason that it was a problem was because the bad guys were pretty deep into the information technology system of the pipeline company. They shut it down. The pipeline company shut it down because they didn't want it to be broken. They didn't want to have to go in and fix it. And so just the threat of having the bad actors get into the operational technology was enough to have the company just shut that technology down so that it wouldn't be a problem. So one of the results was that the Biden administration said, well, this is an issue for us that we need to be looking at. And they began to push this both in executive orders and to push legislation in this space. And so ultimately, what they really want to do is have people report. They don't want people hiding issues when they come up. And we go back to what Champa and Ron were talking about, which is sharing. So that people know, so that law enforcement knows, so that we see where the threats are coming from as quickly as possible. And we're able to do something about it before an entire industry gets shut down.
Yeah, fantastic. Ron, I think, understanding that there are 4 different financial services organizations, different regulators that might require you to report based on the same incident. Can you talk about kind of how you might consider that, maybe even some of the impacts of the timing being different and the considerations for whether to report being different?
Sure. Yeah, that is something that can be extraordinarily difficult to figure out and complex. I think to me, it starts with your prudential regulator. Who is your primary regulator that you have that intersection with on a day-to-day basis, week-to-week basis, et cetera. As Ted and Champa alluded to earlier, you have your base requirements that have been there for years and years if you're a financial institution. But within that, there's often a relationship or understanding between the entity and the regulator about how, why, when you report to them as the primary regulator. Now, for us, it's a very transparent relationship. We are sharing all the time, not probably more than we're legally required to, but that's a comforting relationship where you're building trust and that sort of trust and respect between the two entities, where they know that you're going to tell them when something's going on. And it may not be an official report or official notification. It could just be a phone call, with the person that you're dealing with your regulator all the time. Now, that being said, you have to build from that when you're talking about the other regulators or the other requirements that come. So every time that you have a new requirement that comes down the pike, like Champa mentioned, the 36-hour security incident notification rule is a great example, where we might already be in the practice of notifying somebody within 36 hours of that type of thing. But we had to really take a look and say, okay, well, what are those controls? How do we know that we're doing that? And are we even, in some cases, it's just flagging that you're doing it pursuant to that requirement. Because what I've seen and heard from some financial institutions is it's not that they didn't have a process to do that, or they didn't, weren't prepared for that requirement. In some cases, they're getting dinged on exams and that sort of thing because they can't show that notifications were made pursuant to that specific requirement. So if somebody says, hey, show me the notifications that you you made pursuant to the 36-hour security incident notification rule, or something, one of the other requirements we're talking about. What's really helpful is to have that fully documented in your process so that you're very comfortable with the fact that not only is your process sound, but you're ticking and tying all the specific requirements that are surrounding you with all, states, federal, contracts. There's all sorts of reasons why you have to notify and how you have to notify.
Yeah, absolutely. Great point for kind of contracts. If there's any customer requirements, I think we all know that there can be a lot of different ways that reporting, call it notification, call it disclosure, whatever you need to do. I think, Ron, your suggestion to have that kind of all laid out in terms of, a checklist of the major points is a great point. And I think that, for the purpose of some context, I think another thing that we're talking about is, the materiality, because, not every incident, minor incidents are not going to have to be reported to some of these regulators. And I think, providing some context for what is important to regulators, if the SEC might consider the impact on an organization as measured by the financial impact, I think it's important to see some of the benchmarking that we have here. So you'll see that some information from 2022 has placed the average cost of a breach for financial services organizations around $6 million, and really only a little bit less in 2021. And we know this number is only increasing. I think it's also interesting to see on this slide, sort of in the colorful graphic that you'll see that this is kind of looking at the types of breaches, and you'll see with system intrusion kind of increasing. I think that says something really distinct about that financial impact, but also that operational impact that Ted was alluding to earlier. I think another thing, and I'll cover this kind of quickly just in the just to make sure that we keep up with time, is that financial impact might not be limited to those kind of immediate downstream effects that you'll think of that might have been measured in that 5 to 6 million graph. You think of forensic investigations, reporting obligations, notifications, but the addition of settlements and lawsuits certainly adds to that potential risk of materiality, in the sense that potential litigation is certainly something to consider as you're thinking through whether, what is the impact of an incident on the organization. Ted or Ron, any considerations on some of these kind of notable lawsuits that we've listed here?
No, just to know that they're growing, that the plaintiff's bar has gotten a lot more aggressive lately, and that the addition in some places, like, for example, California, of statutory damages really is going to change the dynamic in this area, because a lot of these that are up here were brought by regulators, and then ended up sometimes, almost all this is settlements. So in other words, both parties are agreeing to these amounts of money. But in the litigation side, one of the things that has happened over the last 10 or 15 years is the plaintiff's bar has had trouble getting traction because of standing issues, because it's not able to show damages. But if a number of jurisdictions start doing what California has done and Europe has done in putting in statutory damages, then a plaintiff doesn't have to show that they had a damage at all, just that their feelings were hurt. And in that case, it's going to prolong these and increase the amounts that are due.
Yeah, absolutely. I'm also going to push past this slide in the interest of time, but we've provided some helpful resources on common vulnerabilities, guidance from FINRA and CISA. So just good resources to look at later. But turning to the New York regulations, Shampa, can you talk about how these regulations are more prescriptive and how the specifics in the regulations vary in tone from SEC and Cercio regs?
Yeah, so as you look, as you see on the slide, like I was saying before, regulations are usually gray in how they provide you requirements, but there are some that are very prescriptive. And that's what you see an example of on the slide. I think that it's helpful, especially when organizations are building their cyber risk program, building their annual assessments. We have a lot of, thankfully, helpful industry standards and guides. If you're familiar with the FFIEC CAT, which is a cybersecurity assessment tool, that's a great tool, in my opinion, for your annual assessments. There is, of course, the NIST cybersecurity framework, which has been a mature risk management framework for cyber for many years now. But coming back to, specific controls, I did want to share a quick example of launching a new product or service, right? So the product team comes to you and says, oh, we are upgrading to this new state-of-the-art online banking platform or client onboarding platform, and everything is hunky-dory. They run you through a quick walkthrough of the customer experience and the process flows. Everything is well documented, and they are going live in 2 weeks, right? So the question that you're sitting there and you ask the question is, where is all of this client data that you're collecting on these forms, on the platform? Where are you storing it, and what is the retention period, or what is the purge process in that particular database or system where this data is going? Oh, we don't have a purge process, but we do have this amazing manual process that we run once every so often. So the question then becomes, I don't think that is sufficient. You have to have an automated purge process, especially because this platform or this, client-facing application is collecting a lot of sensitive information, like social security numbers and things of that nature. And also note that for a global company, there are much more mature data protection and privacy regulatory regimes, such as the GDPR, that we're all familiar with, that actually require these controls as table stakes. They have to be there. So as a privacy and risk and security risk professional, you tell them on day one, you have to have this automated job schedule running, otherwise you cannot go live, right? So some regulations do provide these very prescriptive guidances, some don't, but that goes back to my, earlier point about having some of these as basic foundational cyber hygiene kind of practices embedded in the DNA of your company.
Yeah, thank you, Shampa. And I think, we have consistently alluded to there's this kind of distinction and overlap in some of the requirements. And as you mentioned, these are much more prescriptive, and being able to meet some of these requirements is something that, if you have kind of your organizational wide hygiene, as you mentioned, that kind of leans towards being able to do that. But, Ron, I wonder if you have any thoughts on, seeing as how this is like a New York requirement, you're in an organization with lots of different parts of, regulators or market covered entities that have to kind of respond to some of these requirements. How have you been able to deal with this very different tone of here's a prescriptive list, here's a kind of broad overarching risk procedure?
Yeah, it can be very difficult. I think a lot of times it's that you do take the most prescriptive requirement that is applicable to your operations and try to extend that out to all of the entities to the best of your ability. Now, that's a lot easier said than done, because you might do that for the core of your business, but if you're active in the M&A space, for example, and you're buying startups and they don't even know what you're talking about with some of these requirements, and it's like, okay, well, now we got to get them on board and them on board. And so it's not easy to do that. But I will say what we all are being challenged to do by NYDFS and others is just be more proactive too. I mean, we're historically a very reactive profession in terms of cybersecurity, privacy. Okay, what's the problem? Let's go fix it. You know, there's an incident, now we got to react to it. Whereas if you look at NYDFS, I mean, yes, there are very, very prescriptive requirements. There's a second amendment that's coming that will be very challenging for many organizations. But when you drill into the requirements, these are not new in terms of being presented to financial institutions as at a minimum a best practice, if not a requirement for certain entities. So the more that you can really dig into not just the firm requirements as of today, but looking at the landscape and thinking about what's coming down the pipeline, what am I being told by my regulators in their handbooks that they expect to see as a best practice, and let's start investing now, and that will have a much, you'll have a much easier transition when these new requirements come at you. Again, a lot easier said than done though. That's what we aim for.
Yeah, absolutely. Ted, anything else that you'd like to add in terms of this comparison between New York and some of the more federal broad regulations?
No, I think your slide says a lot of it right here. I mean, multi-factor authentication, annual certifications, data encryption requirements, they get down into the weeds a lot more than the other ones do. They have claimed to build around the NIST requirements, and keep in mind that the NIST policy is basically, or standards, first of all, they're not standards. Second of all, they are, you know, supposed to be set up for like the Defense Department. So that means that Joe's Corner Bank is going to go bankrupt by trying to meet all those standards. And I know there are a number of smaller companies that are get pulled under the, you know, the New York DFS rules that are feeling the same way. They're feeling if we meet this, we're going to be spending a huge amount more money on security next year that we didn't have to spend last year. And, you know, that sort of found cost can be a real problem for companies on the edge and companies that are smaller.
Yeah, absolutely. Thanks, Ted. Well, I know that we only have a couple of minutes left. Thank you so much to everybody who has listened in and participated. I would love, if there's any questions in the group, please feel free to type it in the meeting chat, or since we're kind of done with the majority of our presentation, please feel free to unmute yourselves and ask any questions. Just checking the Q&A. Well, it seems as though we have done a great job of explaining everything to everybody, and there are no additional questions. But I just want to thank so much our presenters and everybody who has participated today. As Lane said, we will be sending these materials after the presentation, and appreciate everybody's attendance today. Thank you very much.
Ladies and gentlemen, this
Thank you.
does conclude today's meeting. Thank you for joining and have a great afternoon.
Thank you.